Welcome to our channel, ladies and gentlemen. The rush with which the Deputy President Rigathi Gachagua was sacked is something that is going to find its way in our courts. It was rushed in the National Assembly when they voted very fast to impeach him. When it got into the Senate, whether it was by default or by strategy, Rigathi was in court, and therefore many feel that they would have stopped for the sake of humanity. But it was also rushed there, and they impeached him. It was immediately followed by a gazettement, and then an appointment of the nominee KindiKi. That again was rushed to be approved at the National Assembly. Now, there's been an attempt deliberately by William Samoei Ruto and his cronies to use a loophole in the constitution. I know whether they call it a lacuna or they just want to take an advantage of it. Because when Rigathi Gachagua went to court, the judge stopped any appointment of Rigathi replacement and extended that conservatory order to any swearing in of that person. But the Ruto camp is arguing that by the time the judge was giving that ruling, the appointment had been made. That's why I'm saying there has been some rush intentionally to beat some constitution. They thought there would be a constitutional crisis, so that they take advantage of it. And I want you to see just two people who are advancing that notion. Moses Kuria, one of the very confident of William Samoei Ruto, and a man who does not see eye to eye with the Deputy President Rigathi Gachagua, was saying this, that the appointment had been done. Justice Mwita's orders, as sought by the immediate former Deputy President, are overtaken by events. Congratulations, Excellency Abraham Kithure Kindiki. In essence, he's telling us that the orders, the conservatory orders, came after the appointment had been made, and therefore they want to tell Kenyans that they can go away with the swearing in. Another thing that he said was this, that the swearing in will take place tomorrow. This tweet was done yesterday. The swearing in will take place tomorrow at Uhuru Gardens from 9 a.m. No cards required. Gates will be closed once the swearing in arena is full. We cannot afford a constitutional crisis. We cannot be another Sudan with the two presidents. For the sake of our nation and our families, we will swear in Kithure Kindiki as president in waiting. Courts can deposit their ruling in the pigeon holes. Karibuni Uhuru Gardens, 9 a.m. You can see that that is the voice of a dictator, the voice of impunity. That despite the court orders, they are saying that they must swear in Kithure Kindiki, and they are citing constitutional crisis. Now, I want you to, just to corroborate this, see what Ahmed Nasir, another friend of William Ruto, see what he was saying. That appointment is what was stopped by Justice Chacha, and the appointment was made before the court orders, not swearing in. So tomorrow's swearing ceremony can go ahead. I have blessed it. This just tells you that these people have got a formed opinion and they are testing waters. If the courts have decided that this is not going to happen because there is an injunction, there is no way they can force the courts. And I have a feeling that the judiciary is under siege, and Madam Martha Koome, Chief Justice, is under pressure. But there is no way she can preside over an illegality, because the same court gave a conservatory order, and in fact, this case was referred to her. She's going to form a bench of judges to look into it. Now, this is a lawyer, Ahmed Nasir, saying that the swearing in was not stopped. Now, it forced Kenyans to start looking for opinions from other lawyers to compare. I want you to listen to how lawyer Kanjama is deconstructing and dismantling this notion that it was only appointment that was bad or stopped, but not the swearing in. And you ask yourself, If appointment was, stopped, how can it go that swearing in was not stopped, yet swearing in can only come after appointment? And I want you to listen to Charles Kanjama, and you will agree with me that on this, Charles Kanjama stopped them right on their way, because this is mischief, a political and a constitutional mischief that they want to ride on.
Just to set it off, do you feel that these court orders, some have been arguing that they've been overtaken by events, do you feel they still are in place?
So first of all, let me clarify that what we have is conservatory order.
Okay.
Conservatory order is the most powerful kind of constitutional order. It is like a 4-dimension court order. It is more powerful than an injunction. It is more powerful than an order of stay. A conservatory order is a 360-degree order. It applies in time, stopping what has happened in the past, preventing something to go on in the future, and even impacting the present. So when you look at the exact wording of the court orders that have been issued, both in Nairobi and in Kerugoya, they are conservatory orders stopping implementation of the impeachment resolution of the Senate. What this means is that it doesn't matter how much implementation had already taken place by the time the order was issued. Any further implementation is stopped by the court order. So that means that we are in a situation as if those additional actions, beginning with the removal from office, which was a direct consequence of the impeachment order of Deputy President Rigathi Gachagua, the proceedings in the National Assembly today, the voting to select Professor KindiKi, all those have been stopped by a conservatory court order.
All right, so if the state was to proceed with swearing in KindiKi tomorrow, as it is, they would be going against the law, just for clarity?
In fact, they will not only be going against the law, they would be committing an act of contempt of court. It would be, I think, quite a serious action. Those who do it might end up finding themselves engaged in an impeachable offense, and they might face sanctions from the court, including sanctions relating to their continuation in whatever public office they have. The court orders are very serious issues. They have to be complied with. And I think I also need to clarify that any action undertaken in violation of a court order is considered a nullity, null and void, and of no legal effect. It would be the same as two children playing a game of make-believe. It would have no effect regardless of who does it. Until the court order is lifted or set aside, it has to be complied with.
So what options does the government have? Is it something that the office of the Attorney General could now, step in, and what can be done if they want to, so to speak, salvage the situation from where they stand?
The way to salvage the situation is as follows. The politicians and the political process played its way out, including the quasi-judicial process in the Senate. The courts have now asserted that they have a right to review the proceedings that took place in the National Assembly and the Senate. So it is now the time, based on our constitutional architecture, for the courts to have an opportunity to review what happened. So the Attorney General would have to get lawyers, either his own staff or external lawyers, or a combination of both, to participate in the court proceedings. They can always make an application seeking to review or set aside the decisions that have been made. But that application would be heard by the 3-judge bench that is expected to deal with the matters on Thursday next week. So there are not much options between now and Thursday, because even if they were to do an application for setting aside, it would probably also come up for hearing on Thursday next week.
Now, if you listen carefully, you'll realize that there's a battery of liars that have decided that they want to support illegality. That's the problem that we have in Kenya, that experts all have also become tribal. That you can imagine a lawyer taking sides just because they don't like Rigathi Gachagua or because they want William Ruto to get his way. I mean, what is the rush? If we know that we are doing the right thing, Rigathi Gachagua is a Kenyan, why don't we give him time to exhaust the attention of the court so that the court will give us the best? If the courts decide that he will continue, then we must respect that. But if the courts say that he is unfit to hold office, then we swear in KindiKi. Both are our sons. We are in this country and Kenya is not ending tomorrow. And we cannot gag Rigathi Gachagua just because of some selfish and personal interests. This is a legal matter. And I always don't like this kind of talks that we cannot respect our courts. And who started this? It was, William Samoei Ruto, who said that he was not going to respect court orders as far as, you remember when the NHIF implementation was in court, the housing levy was in court, and William Ruto was saying that someone wanted to sabotage his development agenda. And therefore he said, I was given a sword to deal with these people. I'm not going to respect court orders. You know, Madam Martha Koome should have come out breathing fire. But she was quiet, and you can see this thing having its roots. People like Moses Kuria are now telling her that we will go on with the swearing in. Ladies and gentlemen, we cannot swear in Kithure Kindiki while we have noticed the courts have not heard and determined the case of Rigathi Gachagua. That is it. And we cannot be personal. We must let the court process, to go to the fullest. Otherwise, we are building anarchy, and that is how tomorrow will be. So you are telling me that if Kithure Kindiki and William Ruto disagree there, then we will kick out Kithure Kindiki, swear in another deputy president without listening to our courts. And then if you don't have, faith in your courts as the executive, so how then do you expect a normal Kenyan to have faith in the courts? We cannot run this country with impunity because we are dealing with a constitutional process. We cannot break law while trying to implement another law. We cannot break or breach our constitution while we want to implement another constitutional order. Let all the branches of the government do their part. The National Assembly and Senate had done their part and they impeached the deputy president. And I remember Rigathi Gachagua sought for more than 5 times the intervention of the courts to stop the process at the National Assembly and the Senate. But the courts refused because they said there is separation of powers. Parliament and National Assembly have done their part. What Moses Kuria and William Ruto must understand is that just as Parliament and the National Assembly and the Senate were given their term, were given their part to complete this process, they should also be, democratic enough to obey court orders and let the court process complete. They were given their part. Let, the court process end well, then the executive will go on with whatever they want. And I think it has been stopped.